Hello. I'm talking today about what they call the bonus proprius orders, which are orders against the legal practitioner by the court. So, in other words, I go to court and represent you or another person that's been wronged by the bank, and the bank tries to get me to pay for the costs of that court case. Now, most of the time, courts dismiss this, but especially with ABSA, who in 2018 or just asking in every single court case. Eventually, they found somebody, some judge, who was sympathetic to them, that they managed to persuade that the bonus proprius costs were appropriate. And they managed to get an order against me, which was ended up being about 200,000. And then in all the future court cases, they also said, oh, they've already got an order against me. And so it ended up being about 600,000. Now, what were they accusing me of? Were they accusing me of stealing money from my trust funds or something really serious? Not at all. No dishonesty, not disobeying the courts. Like, remember the Zuma trials where the ministers of the government were refusing to do what the constitutional court said. That's legitimate reasons. But what they said I'd done, if I can discern correctly, is one, they said that my attorney that briefed me didn't do it properly, or there wasn't a correct relationship. Very subtle things. I mean, nobody said that I wasn't briefed. I was an advocate in these days, and you have to be briefed by an attorney. It wasn't that. They take that very seriously, but it wasn't that. I was totally briefed, and there was lots of evidence for that, and there was nothing in the judgment that said I wasn't. They just said there was something inappropriate. It's very vague. And then my website was too strong against the banks. Surely in a democracy, that's okay. I mean, I amended all these things. The court says do it. I'm then an advocate, now an attorney. You do what the court says, of course, but is that? And then they said that some of our papers were similar to each other, too similar. Again, everything you get from the bank looks just about the same. It's ironic, but you get a summons from the bank. It's very similar to their other summons you should get to other clients. So these three things, I don't think anyone listening thinks that they're really very bad. And yet I ended up, and still have at the current time, an order of 600,000 Rand against me. Now, this is obviously a matter of intimidation, and I've seen lots of people back out of cases against the banks because they've been intimidated like this. So it's something that needs to change in our country. We need to change the law so that there is a place, as I say, dishonesty, refusing to do what the court says intentionally, with many reminders, not unintentionally when you forget to do something, as I have on occasion, and everybody does. Now, in the class action as well, now all four banks are asking for the bonus proprius costs against me. So again, it's their modus operandi, intimidate. But if costs are awarded against me in this matter, there's four big banks that have been fighting this for 5 years. The biggest, most expensive law firms in the country. For the most part, there's some that aren't. But I'm sure that the cost would be, if that was 600,000 for four other cases, in 2020, 2018, 17, 18, then I'm sure today, for this much work, if they award against me, it's going to be 5 million, 10 million, something like that. It's going to be ridiculously high, millions of Rand. So obviously I'm not going to be able to bear that. I'll probably have to sequestrate because I was willing to defend the people of South Africa against the banks. So it doesn't seem right, and it seems that the law needs to change in that respect. I mean, they might not be awarded at the moment. They've not been awarded, so I'm not saying that that's going to happen, but there's a lot of constitutional problems with the way that the bonus proprius orders work. So the first one is that they just say, give reason why you shouldn't have the bonus proprius orders against you. That's what the court says, and that's not unusual. That's what every court says with the bonus. Now, how can that be? Surely, in any legal matter, they say to you, you're accused of this, 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 and this. It's like a criminal matter. It's a punishment. This, it's not civil fully. It is in a civil sense, but it's a punishment, and everybody's got the right to know what they're accused of. There should be a list, and maybe the banks produce a list, and then the court says, no, not that, not that, not that. This is what we think you need to defend yourself against. Actually, maybe the banks, after it's permitted, the banks should have to substantiate it first. But you definitely should know. I mean, I'm still not sure entirely what I got. The bonus proprius costs awarded against me. Or what it was mostly, and how much was for this. In criminal matters, there's financial limits. It's variable a bit, but it's like if you commit a theft, if you rob a bank, rather than the bank robbing you, if you do something, then you know roughly how much the fine is for that, or the prison sentence. But here you don't. There's no, and there's also a disproportionality. Obviously, 600,000 rand is too much for the offences that I was accused of in these days. I don't know what it should have been. Somewhere maybe 10,000 or 50,000. They should have taken into account that I've never been accused of anything before, of any kind. But definitely 600,000 or 5 million is disproportionate to anything I'm accused of, and there's no method in the system to stop that happening. And then the aggregation factor, that in criminal matters and in the general principle of law, you find out first if somebody's guilty or innocent, and then, only then, does the judge get to know what they've done before. So whereas in this case, the bank goes to and says, we want the bonus proprius orders, and before the judge has decided whether he's going to give the bonus proprius orders, they're saying he's had another one before, and they use that as justification for getting another one. That's totally against the principles of how law works in every other area, and it can't be. These are constitutional principles. They're the right to a fair trial, and legal practitioners should at least have the same rights as suspected criminals. The reason why criminal rights existed to start with is because there was the death penalty and they could die. But even a long period of confinement or a large fine. Where there's large penalties, definitely people must have the right, and all the things that I'm talking about must apply. It can't be that legal practitioners don't have the same rights when accused of doing something wrong as criminals, suspected criminals do. So there are certain cases where they say this is the kind of things that we'll give the bonus proprius costs for. And usually it's quite serious things. They say it's exceptional, but it wasn't. Eventually they got them against me because they asked and asked and asked, and that should be illegal somehow. That you can't just keep asking until you get them. It's a form of intimidation. I called it corruption in the actual court case, but I'm not meaning that they bribed the judge. That's not that kind of corruption, but it's a form of corruption. So yeah, let me think. What was I going to say? So yeah, the aggregation effect, where you get one and then you end up getting four. That also needs to be reviewed. So they say, okay, for the one thing that you did wrong, they say, oh, you did it wrong in all these different cases. So we're just going to add all that on. It means that the fine, if you like, or the costs rise by exponentially, and it ends up being hugely disproportionate. So obviously what this eventually does is that people are reluctant to defend poor people unless they've got a huge fee. They're just not going to take the risk, and that's sensible, I'm afraid, and that is what these orders have done. Not to me, But to other people, I find a lot of people, I get cases where they say, oh, no, ABSA threatened them with de bonis proprius costs and they withdrew. Often. And ABSA do another thing, or I've heard, I don't say I've not got evidence for this, but it seems that people that are on the bank's panel for conveyancing, legal firms or legal practitioners, if they sue the bank in court, then the bank removes them from the panel. So it's another form of manipulation to stop banks being sued when they do things that are clearly wrong. And when I came to South Africa, when I started doing this, people would come to me and they say, look, we've been to 17 lawyers and we haven't been able to find anybody that's willing to represent us against the banks. I mean, the banks have good lawyers as well. It's difficult. But there's also this process of intimidation that they try. And, in any other cases, even most of the other banks usually don't stoop to this kind of play the man, not the ball type strategy, not repeatedly anyway. Although all of them in the class action have. The stakes are much higher. We've got 60 billion at stake. So, they'll do whatever it takes, it seems. But let me clarify that. I'm saying that our de bonis proprius, I'm not saying they'll do anything, but they're going to de bonis proprius orders when it's not appropriate. So they're saying, they're accusing me of like civil things, like not filing things on time, which they also haven't filed things on time. Things like that. It's not like you've stolen or disobeyed the court intentionally and repeatedly. There's times when I've not been able to get things on time, but that's because we're working full tilt. The kind of things, they just come up with lots and lots and lots of things, complaining about this, you have to do this, you need to do that. So I do these things, but it takes time, and sometimes you miss the deadline. But it's not intentionally refusing to do things or anything like that. But that's the way it's been taken in the admission order particularly. It's like, oh, well, you didn't obey this order, you didn't do this. But it's only because I'm one person against 4 banks with 5, 6 staff each. So it's more than 20, 30 people that are doing the work on their side. And they still have been late in filing lots of things. Their initial answering affidavits were very late, and then they blame me and say I didn't provide them with documents, but they could have filed within time and then filed a Rule 30. Investec did that actually, but the other 4 banks could have done that and filed on time. There was no reason for them to be late. And then repeatedly, right through the whole thing, they've been late repeatedly, and yet they come against me. But that's not an order for de bonis proprius costs, But I need to argue that, so I won't say too much about that particular de bonis proprius order, because I'm still arguing it, and the judge might find that there's no reason or not sufficient reason to give de bonis proprius costs against me in this case. They will be deciding that against on the 24th of February. It's currently January 2026, so you might be watching this after, of course, but that's what we're thinking now. But I just also want to tie this in with the video called The Need for an Act, because I don't know if we can pass an act on de bonis proprius costs. It might be the Rules Board of the High Courts that would work that one out, because it's more in the judiciary than something the executive parliament would do. The executive and then parliament, the legislature. But I just wanted you to understand, that this is the way the banks are acting. And the reason we need an act is we can't rely on the banks to do the right thing. The right thing here, obviously, is to say we're sorry about what we did. We sold all these people's houses, 100,000 people's houses for much less than they're worth, or at least a large proportion of them. And we realize that cannot be morally justified, and we're sorry. The banks are not doing that. You see car companies, for example, all the time doing recalls and saying, oops, there was something wrong with our, something about the car. Bring them back, we'll fix it. That's what the bank's mentality should be, but it's not. They say, sue us. That's not okay. So what that means is, because people mostly can't afford to sue them, as they know, and when you do sue them, they put good lawyers on them. We beat them sometimes, but it's not an easy thing to do. So we need an act that says, and this is separate from the class action, completely separate. We need new rules about the bonus proprius cost. That's the theme of this. But we also need a new act that just goes through and says, when you're trying to repossess somebody's house, you can't do this, you can't do that, you can't do this, you can't do that. Just to bring us in line with the rest of the world in good practice. That's what we need, because these things like the bonus proprius costs show us that the banks are not ethical institutions like they claim. This is a morally reprehensible thing to do, to attack the person that's defending the poor person, the ordinary man on the street, woman on the street. That's not okay. You answer the arguments, but you don't attack the person that's defending them to try and make sure that nobody's brave enough to defend the poor and ordinary person against the bank. That is not how they should be allowed to play the game. And it shows their ethical foundation. It shows what they're like.